So before we start the event tonight, I just want to take a very brief moment to begin by acknowledging that the land on which we all gather is the traditional unceded territory of the Syilx Okanagan Nation and their peoples. So while we're all gathering from near and far, let's just take a quick moment to acknowledge the traditional owners, past and present, of those lands. So with that being said, let me introduce myself. My name is Brendon Coe. I'm going to be the host for the event this evening. So I am an investment and insurance specialist at Interior Savings Credit Union in the Thompson region. So I work out of Kamloops. My wife Ashley and I moved out here about 3.5 years ago from Kelowna, where we were born and raised. But I am happy to say that we are Blazers fans now, so please don't hold that rivalry against me. So let me welcome you all to our 8th annual Okanagan Embrace Aging Month. So Embrace Aging is co-hosted by the Institute for Healthy Living and Chronic Disease Prevention at UBC Okanagan, also Interior Savings Credit Union and Interior Health. So Embrace Aging Month was actually launched 8 years ago to celebrate and raise awareness about positive aging. So we've once again organized a handful of educational opportunities and events throughout the month of March. These sessions are intended for everyone, young and old alike. They focus on a variety of topics related to healthy aging and ways to improve the quality of life for our seniors and their family caregivers. Our #1 goal is to inspire everyone to embrace positive aging. So a couple housekeeping items before we get into the actual presentation tonight. We do have closed captioning. If it is interrupting your stream, you can actually turn that off at the bottom. We also have a chat feature at the bottom of your screen where you can feel free to ask questions or make comments throughout the event tonight. We do have quite a few attendees, and we've already had questions rolling in ahead of time, so we are definitely going to do our best to answer as many of these questions as possible. But keep in mind, if we don't get to your question, you will be receiving a survey email after the event, and you can make a request on there to have a follow-up afterwards. So don't worry if we don't get to your question. So tonight we have a special event for you, brought to you by Interior Savings Credit Union, and our topic tonight is Estate Planning Essentials, What You Need to Know. So we brought in a couple amazing guest speakers from Fulton Company LLP in Kamloops here. So first and foremost, I'll introduce Leah. She's a lawyer at Fulton who specializes in helping people plan for their futures. So she has a broad background in business and property law, but she also has over a decade in wills and estate law. So Leah has plenty of experience with even the most complex estate planning needs. When she's not in the office, she's busy spending time with her 2 young children and her husband. They love to spend time at their rustic cabin, taking in all the great outdoor activities that we have out here, like mountain biking, and she's been getting back into skiing again. So last but not least, we also have Tyson McNeil-Hay. He's also a lawyer at Fulton. He primarily resolves estate disputes. So he brings a lot of invaluable experience and some unique insight into the potential risks and their repercussions that can happen during the estate process. Outside of work, Tyson's also a pretty busy guy with 3 young children and a spouse. He also loves the outdoors, biking and skiing. And during his education, he actually spent some time abroad, so he speaks a little bit of French and Russian. So pretty interesting background. So without further ado, thank you for joining us tonight. So Tyson and Leah, the floor is yours. You're muted, Leah.
The first strike against me for the night. Sorry about that. Thank you very much for the introduction, Brendon. We'll just kick it right off and get going here. And thanks everybody for joining us from the comforts of your own homes tonight. First of all, just to address the environment we're all operating in these days is the COVID environment. And I wanted to reassure you right off the top that it is still possible to do wills and all the estate planning documentation that go along with wills, even through this COVID situation. So the way we're doing things, and most lawyers are operating now, are by using video conferencing and phone client meetings as much as possible, reducing in-person meetings with clients. And depending on the type of document it is that you're signing, it may be able to be signed at home with 2 lay person witnesses and not require the signature of a lawyer. But if we're doing a will or a power of attorney, and that has to be witnessed with 2 people that require, those documents require 2 witnesses. Some of that can be done virtually now. So it is possible to be in front of a lawyer by video conference and have that lawyer watch you sign your documentation. And through some recent legislation that's been passed in British Columbia, that can be utilized to make sure your documentation is valid and correct. Oftentimes, we are still seeing people in person with appropriate precautions, and there's lots of flexibility to meet your needs. But if you're somebody who just simply has to isolate and cannot be in front of a lawyer, video conference witnessing is still an option for you. So a quick note for you on that. So tonight, when we're talking about estate planning, what are we talking about? And there's 3 main themes before really that we're going to tackle. So we'll talk about what is an estate and what does that mean. We'll talk about probate. What is it? When do we need it? We'll address something called wills variation, which is fairly unique to British Columbia, but it underlies a lot of what we do as estate planners. And we'll of course address incapacity planning. So planning for the event that you are unable to or rendered incapable of managing your own affairs. And throughout this, we're going to be addressing these tools. These are tools in our toolbox, and these are the most common documents, if you will, that we would prepare for our clients. So wills, estate planning also involves in setting up jointures or assets that are jointly held in the right circumstances. It involves potentially multiple wills or alter ego trusts for wealthy individuals. And then powers of attorney and representation agreements are the planning for incapacity piece, which we will touch on later. So underlying themes here as estate planners, these are what is informing our conversations with our clients. And much of this is unique to BC. Number 2 and 3 specifically are indeed. So I'll explain what an estate is, and then I'll talk about what's the probate requirement in British Columbia, when is it needed? And then wills variation, what does this mean and why do we worry about it? So starting off with the first theme of an estate, and what is it? So your estate simply means the assets that you have at the time of your death that are passing through your will to your beneficiaries. So it excludes assets that are jointly held with right of survivorship with another person, or assets that are beneficiary designated to another person. Those assets that are jointly held or beneficiary designated pass outside of your estate. The will does not cover them. The will and the executor have no responsibility or authority over those assets because they are not part of the estate. So why is that significant? Well, because the assets that are in your estate are subject to probate fees. I'll talk about those in a moment. They're subject to creditor claims. So that means they are the pot of assets that's available to pay your debts and your expenses, including your last tax return and your terminal tax and your estate tax. That's all triggered by your death. So those are the assets that will be charged with payment of your debts. The assets passing outside of your estate, the beneficiary designated or jointly held assets, are not subject to payment of your personal tax and personal debts because they're not in your estate. And then also the assets in your estate are also subject to wills variation claims. And we will touch on that later, but that's something to keep in mind. So these are the assets that would be at risk if somebody contests your will. Underlying theme number 2 is probate. So what's the big deal about probate? Well, if we have an estate and we have assets within that estate, then depending on the type of asset or the size of the asset, or how valuable it is, probate may be triggered. So there is a general requirement in British Columbia that if a person dies with an interest in land, so if they hold a mortgage, they've lent money to somebody else and they have registered a mortgage against property as a lender, or if they own property in their own right, or maybe they hold a registered lease. So any kind of land title office registration in your name is going to require probate in order to deal with that land title interest or that land interest. The land title office is going to require your estate to be probated before they will allow your executor to deal with your land interests. Similarly, financial institutions will, in most cases, require probate before they will allow the money, the funds in the accounts, to leave their institution. So before they will give that to the executor. And auto plans, another example. So before you can transfer ownership of a vehicle, in many cases, the auto plan insurance agency will want to see probate before they will let that happen. And why is that? That's because the grant of probate is the authorization or the rubber stamp, if you will, from the court, the BC Supreme Court, validating that the will that's been presented and the executor named in the will is the rightful will and the rightful executor. So with that court authorization in hand, the executor can then go to the third party, the land title office, the bank, auto plan, present the grant of probate, and that third party then has confidence and comfort that they should take the instructions of that person who's showing up in front of them asking for the money or asking for the asset. The third party is allowed to deal with on the basis of that grant of probate. And if it turns out that, for example, there was an even more recent will than the one that was probated, and there's a different executor named, but that third party has followed the direction under that grant of probate and allowed that asset to leave their control and gave it to the named executor in the grant of probate, then that third party is absolved from any liability. They're not liable for any loss that the estate then suffers. So that's why third parties require that grant. It's for their protection so that they know they're dealing with the rightful person. So to give you a very common situation scenario example, two spouses and one of them passes away. Let's assume that they have joint assets. Their bank accounts are joint, vehicle, land, recreational property, it's all jointly held. In that case, one spouse passes away, the survivor is already named as joint owner and will then already be the owner of all those remaining assets. There'll be nothing flowing through the estate of the first to die. Then when the survivor passes away, that survivor at that point has the land, joint bank accounts, vehicles, and that person then has an estate. Those assets are not jointly held with anybody else. They're not beneficiary designated. So that last to die spouse needs a will to determine where those assets are going to go, and they need an executor to be named in their will. This is the same example, but telling you how it applies with probate fees. So when we have the two spouses and one passes away and there's nothing in the estate, there's no probate fees. But in British Columbia, probate fees are 1.4% of the value of the estate, the assets flowing through the estate. So when that second spouse survivor died, if they had assets that were amounting to $300,000 here, the 1.4% calculation puts the probate fees at $4,200. So on $1 million, it's $14,000 of probate fees, and it can add up quite quickly. And of course, probate fees are only levied on the assets in the estate, not the ones passing by beneficiary designation or by joint ownership. So now that we know when we might need probate and what some of the implications are, the probate fees, I'll now tell you what the probate process is. So this is basically a paper-based process. It typically does not require anybody appearing in front of a judge in a courtroom. And the process starts with, of course, identifying what you think is the last will, and then notifying the beneficiaries that you are the executor appointed in the will, and that you're intending to take out a grant of probate, and then you give them a copy of the will. They're actually entitled to a full copy. Then you have to compile some information for the court. So you're going to file a number of affidavits explaining to the court some of the history and the background of yourself and the deceased person. And the most interesting piece of affidavit evidence that's put forward is actually the listing of assets, or the statement of assets. So the purpose of this document is to make an official record about what the assets of the deceased were as of the date of their death. So here we're talking about market value of the house as of the day of death, money in the bank accounts and the investments, vehicle value, if you have shares in private companies, what those were worth at death. If you have assets out of the jurisdiction in another country, what those were worth. And that gives the court a snapshot, and it gives the beneficiaries a starting point. So they see what the official starting point was as of day of death. And from there, they can follow along as the administration of the estate progresses. They can follow along and see what happened and what the executor did with those assets that were existing at death. That list of assets is also what the court will calculate that 1.4% probate fee on. This next slide is Tyson.
Thanks, Leah. So this is where, as the introduction noted, that I deal with more with these items when they're disputed. And so one of the disputes I deal with is wills variation disputes. So what is wills variation? It's essentially part of our wills and estates legislation in BC that allows a surviving spouse or child, so only a spouse or child, to contest a will on the basis that it's unfair or inadequate relative to the gift that's given to them. And as Leah said, it's unique. The only other province in Canada that allows adult children to do this is in Nova Scotia. The other provinces all have the ability for spouses to get a fair share, and for dependent children, but adult independent children is unique to BC and Nova Scotia. And who can bring a claim? As I said, it's only spouses and children. A spouse is defined as either a formally married spouse, where you've actually gone through a marriage ceremony, or what's called a marriage-like relationship, and that has to last for at least 2 years to trigger that right. Who is a child? As I said, it can be either a dependent child, a minor child, or even an independent adult child, and that includes biological and adopted children. Stepchildren, however, don't count. So it's different than family law. You might have a stepchild that you stood in the place of a parent for. That doesn't give them rights to your estate unless you actually adopt them. Siblings and parents similarly don't have these rights, and importantly, in some cases, grandchildren don't have the right. And I've seen a few sad cases where the one parent or one of the children predeceased their parent, that the predeceased child had children, and those grandchildren were able to be written out of the will without any wills variation recourse. And people often feel that that's quite unfair. So, sorry, Leah, I think this is back to you now.
You went one too far, Tyson. Slide 14 was.
Oh, I did. I missed one. Sorry. Yeah. I'll go back one. Trying to get the hang of this.
Yeah.
Controlling this. Sorry, everybody. So, still on wills variation, what it is essentially is the person who feels that they've been treated unfairly is asking the court to rewrite the will, to change the will in a way to give that person a larger share, a fairer share, as they would put it. When these cases go to court, it's a very broad range of circumstances that the court's going to consider. And the sort of the test that the judge is supposed to hold in his or her mind is to consider what society reasonably expects a judicious parent or spouse would do in the circumstances. And so the factors that go into this are obviously extremely broad, as I said. The size of the estate, the number of children, in the case of a spouse, the length of the relationship, the length of the marriage, whether there was caregiving provided for each other. When you have a disinherited child, there's also lots of cases that look at, well, what was the relationship between the parent and the child? Did the child have a legitimate expectation of inheritance, or had they sort of estranged themselves from their parent? Does the child have a disability? Are they likely to have difficulties in the future that make it sort of judicious to give them a larger share? There's so many circumstances that can be taken into consideration that one of the hard parts of my job is telling people who have this sort of dispute, whether it's they're on the challenger side or not, or on the other side, what the likely outcome is to be, because there's so many different factors that the court takes into consideration. There we go, Leah. Now it's back over to you.
Thanks. So those three key underlying themes really inform what we talk about with clients when we're talking about estate planning. So we're always thinking about what is in my client's estate and what's going to pass outside of the estate. So what does the will have to cover? And we're talking about probate planning. So this will, does it need to go to probate? And if so, is it set up properly? And then will's variation. And are there risks here? Does the client need have a plan in mind that gives rise to their will being challenged? And are there recommendations we can make to mitigate that risk and that will exposure? So here is a list of some of the tools that we use. And I'll talk about each one of these in turn. So we'll start by the will, or with the will. And of course, these are the key elements. So all wills should have an executor appointed, beneficiaries named, chosen guardian if appropriate, potentially some trusts or testamentary trusts, and then give the powers that the executors need. So talking firstly about executors. This can sometimes be a simple decision for clients, but oftentimes it can be one that they struggle with because the executor's role is long, it's ongoing, it can last for 2, 3, sometimes even more years. That executor is stepping into your shoes, so they're assuming your world, your life, your issues, and they're liaising with beneficiaries, and there may be difficult personalities or personal conflicts or potentially even ongoing litigation. So can be a lot of complexities in becoming an executor. So the best thing you can do is have a frank conversation with your executor, proposed executor, and ask them, are they willing to do this? It can't be thrust on somebody. You can't force someone to be an executor. If I named Tyson as my executor and he didn't want to be the executor, he would just sign a resignation and he would step away. So sometimes it's a bit of a surprise when you find out you've been named as an executor, but you don't have to act if it's not something you're comfortable with. So the best executors are those who are, of course, meeting these characteristics here. So capable and willing, trustworthy and responsible, organized, that's a huge benefit. Ideally, there's some longevity planned in, so they're likely to outlive you. Or if that can't be planned for, then choose a second or third alternate so that you have a few different options if your executor has predeceased you. And ideally, for convenience at least, it's nice to choose somebody who lives near you. If you have an appointed executor who's across the country, there will be travel expenses because undoubtedly they will need to come to your hometown at least once, maybe twice, sometimes more, in order to get themselves established with the bank and have their photo ID taken so that they can start accessing your assets. Professional trustees are an option. So if your estate is complex and you may have a reason for not wanting to choose a child to be an executor, there's an opportunity to hire the services of a professional trust company. And they exist in British Columbia. They've been, many and most of them have been around for decades and decades. And the arrangements are usually pre-made. So you sign a contract with them where you bind your estate, and your estate would then be subject to that contract for their fees. So the fees would be pre-arranged. Often have questions about, is it possible to name a child or more than one children, or a beneficiary? And the answer to all of those questions is yes. If you name 3 children as your beneficiaries, you can have them, all 3 of them, as your executors. but it's very impractical and can become very cumbersome. So keep that in mind. Sometimes what you may want to do is name all three of them and tell them that you expect one or more of them to back away if they don't want to be involved, leaving it in the hands of just one of them. And that gives them the flexibility among the three to decide who's going to be the point person, and the other two would step away, leaving the job in the hands of just one. It's much more convenient for there to be one person in charge than two or more, because all decisions have to be jointly authorized, joint signatures, joint instructions given to lawyers and accountants. It can be very cumbersome if there's more than two or more executors. The note about residing in BC is important because if you have a executor who's a resident of the United States in particular, there can be some tax outcomes or tax consequences for that. So it should be explored. You need to really look into that before you make that decision. Executor fees, and of course this is a big job. So yes, executors are allowed to be paid, and there's a Trustee Act in British Columbia which sets out the default. So it says that if the will says nothing about what the executor can be paid, then the default in British Columbia is a maximum of 5% of the assets in the estate. And it's a sliding scale based on complexity and the amount of work involved and how good of a job the executor did. So the executor at the end of the day basically has to make a pitch to the beneficiaries and say, I know the maximum is 5%, 2.5% is about average. I think I did a pretty good job and this was a fairly complex estate for these reasons, and therefore I'd like to be paid 3.5%. So that pitch is put forward to the beneficiaries and they would approve it. And if there's a disagreement and it can't be resolved, then somebody like Tyson would be taking this matter to the court and having the court rule on what an appropriate executor fee is. And sometimes that has to happen if one of the beneficiaries is a minor child, because minors aren't able to approve executor fees. Anybody under 19 can't. So by default, we know that we would be seeking a fee award from the court when we know we have a minor beneficiary involved. And when I say approved by the beneficiaries, I mean approved by the people who are residual beneficiaries. So who are getting a portion of the last amount of the estate. Anybody who's getting a flat fee or a flat gift, so $500 gift to your next door neighbor, Jane, Jane would not need to approve executor fee. Doesn't matter to Jane one iota what the executor gets paid, as long as Jane gets her $500. So it's just those beneficiaries who are entitled to a percentage, because their percentage is determined in part by, or what's available for them is determined in part by how much the executor gets paid, because that comes off the top. Okay, Tyson.
Thanks, Leah. So when you're considering who to appoint as an executor, who would be a good executor, one of the things you want to think about and know is what the executor's duties are. And so legally, we talk about these two different duties the executor has. They're sort of two sides of the same coin to some extent. The first one is the sort of really onerous one. It's the fiduciary duty. And it requires that the executor act towards the estate with utmost good faith. And that has all sorts of sort of sub duties to it, including a duty of full disclosure and transparency to the beneficiaries, a duty to avoid any conflict of interest, and those sorts of things. So that's a duty of honesty. It comes from Latin word fides, I think, which refers to honesty and integrity, and it's a very onerous duty again on the executor. And it's one of the ways that the beneficiaries can call the executor to account if something goes wrong. The other duty that the executor owes to the estate and the beneficiaries can be called the common law duty. And it's a duty of reasonableness and prudence. And it's particularly, it comes into being when you're thinking about investing or protecting the estate's assets. So this is a duty that requires the executor essentially to treat the assets just like they would treat their own assets, in the sense of making sure they're protected, invested in a prudent way, and that sort of thing. So those two duties are really the big things that an executor has to take into consideration. So that again harkens back to what Leah said before. You want someone who's honest, and you want someone who's competent and able to do a good job. And the executor duties really are they're sort of backloaded in the way that the beneficiaries can actually make sure those duties have been upheld by the executor. So I often end up in a situation where I get consulted by a beneficiary. The estate's been ongoing for 2 or 3 or more years. They're not sure what the executor is doing. Maybe they got a little bit of money, but they have no idea what the executor is doing. There's always suspicions in those kind of cases that maybe the executor's taken all the money themselves. And the big thing, the first thing I almost always do in every one of those files is I find out that there's been no accounting done to the beneficiary. So the beneficiaries are in the dark about what's happened with the estate. And so the first thing I do is write a letter to the executor saying, you need to account. You need to give us a true and complete accounting of your dealings with the estate. And this is something that executors are required to do on an ongoing basis, but it tends to happen more at the end when they're ready to distribute some money. And the executor's got to produce this statement telling the beneficiaries, here's the assets I had at the start, here's all the money I received, here's the expenses I paid, and here's what's left, and here's how I'm going to distribute it to you. And at the same time, that's usually the time that they would ask the beneficiaries to approve their executor fees as well. Those then are sent to the beneficiaries, who are asked to review them and approve and consent to them, hopefully. And as Leah said, if they're not approved by the beneficiaries, then those accounts can go to court to be approved or passed by the court, as we say. And there's again all sorts of disputes about that, but quite often it comes down to the amount of executor fees that are being claimed. And I think we're back over to Leah.
Yeah, thank you. So now that we know some of the characteristics of an executor and some of the duties of the executor, I'll move on to the other components of the will. So the will, of course, also sets out who your beneficiaries are. We're talking here about who's going to receive your personal effects, but all your other assets too that are passing in the estate. So maybe that's land, maybe that's cash, maybe it's jewelry, maybe it's artwork, vehicles. And typically, it's contemplated that the executor would be liquidating, selling all of those assets, except for maybe the personal effects, because usually the will has a clause saying that the personal effects would either be given to one individual or divided among a number of individuals. But other than that, it's contemplated that the executor would be selling the house, cashing in the investments, selling the recreational property, and pooling all that money together. And then the will goes on to say what should happen after all the debts and expenses of the estate have been paid. We have a residue, the pot of residue is left over, and what should we do with it? So this is where beneficiaries are named. And of course, we're always typically addressing spouses. We're talking about children. We may involve stepchildren. In a blended family situation, the two spouses might make wills that look identical. And they might say, regardless of which of us dies, we are both going to distribute the estate of the survivor. That will would distribute the estate among biological children and stepchildren. So there may be a promise between those two spouses that they're going to always keep their stepchildren involved in their will. Charities are sometimes a common beneficiary, and more commonly, charities are chosen sort of as a last case resort. If all else fails and all of my beneficiaries die before me and there's nobody here to take this estate, then you can go to a charity. Or sometimes a flat figure is done, which is a very simple thing to do in a will. You could leave a small $1,000, $5,000 donation to a charity, and it can be a very nice little legacy to leave. Grandchildren, are most typically not involved in their own right, but they do often take the place of their parent. If their parent dies before them, then usually that share of the inheritance is preserved and then passed down to the grandchildren. And in the case of young children or grandchildren, the question always becomes, well, who's going to manage that money? And I'll talk about that next. And of course, you can involve extended family as beneficiaries. You can involve friends. So you have many, many options But of course, you're always constrained by the wills variation laws and that common law in BC. So if you deviate and you don't give the majority of your estate to your children and your spouse, or some combination thereof, and you give your estate to extended family members, charities, etc., you're highly at risk of a wills variation challenge by those disappointed spouses and children. So when we're talking about beneficiaries who are minors, or in other circumstances too, we may be building into your will a trust. And a will that's found in a trust is called a testamentary trust. So it comes into being through your last will and testament. And it doesn't come into being when you sign it, when you sign the will, but only when you die. And at that point in time, you may say that a beneficiary's share is to be held for them in a testamentary trust through your will. And you'd have to choose a person to be the trustee who'd be managing that money and making decisions about when and how much to disperse to that beneficiary. So we will see this regularly for minor children. It should always be done if you have a child or a potential beneficiary who could be under the age of 19, which is the age of majority in BC. So those young minor people need to have trusts established to manage their money until they're at least 19. That's the minimum age. You may decide to postpone that division a bit longer to give them time to become a little bit more financially mature. So you may postpone that until age 25 or 30, and then the trustee's just in that role that much longer. We do often see this for children who have just difficulties in life, spendthrift children or people with substance abuses issues, and it would be very much to their detriment to allow them free access to cash. In that case, a trust is the most obvious and appropriate option. And also disabled people who are receiving benefits, person with disability benefits from the provincial government, PWD benefits, that's a regime in BC with a bit of like a pension, disability pension. And there's an income threshold and an asset test that will enable you to keep your pension. So if you're inheriting a big sum of money, it might disentitle you from your PWD pension. So if you have a beneficiary who's disabled and receiving PWD benefits, really, really think about a trust for them in your will, commonly referred to as Henson trusts. So after we set up our trust for our children or anybody who may benefit from a trust, then we're going to talk about guardians. So this is just, of course, a requirement for folks who have children who are minors, under 19. So you do need to name a guardian. In most situations, if I passed away and I didn't name a guardian, my children's biological parent, their father, would be by default be their guardian. But some parents, particularly parents who have split up, they have parenting arrangements or they have guardian and parenting rights granted by the court through a custody agreement. And yet, so sometimes it's a little more tricky than that, and you actually have to look at those custody agreements and see what rights I have, because I can only give away the rights that I do have. And then I could appoint somebody else to take over my custodial rights of that child. Every time we're talking about guardian appointments or executor appointments, I'm always urging my clients to do backup choices in case the first name doesn't work out. And then a word of caution, so if there is no surviving guardian, maybe both biological parents perish and they haven't named a guardian, the default is that the provincial government of BC would come in and it would be the office of the public guardian and trustee who would take over. They would become in charge of the minor child and make all the personal care decisions for that child, and then also manage the minor child's assets, so their person and their estate. And that would be the case until there was a guardianship order granted and saying something different. So a family member most commonly could apply for guardianship, and then if they were granted guardianship, then the public guardian and trustee's office would step away and they wouldn't have a role anymore. So those are the main components of a will. So that rounds out our conversation about wills and what you need to think about when you're making a will. And now I think at this point in time, we're going to have a 5-minute break. So I'm just going to leave this slide on the screen. Feel free to take a refreshment break. And these are just some fun facts about my law firm, Fulton Company. And this screen is telling you that we've been around for a long, long time, since 1885, operating in Kamloops here. So we have a lot of history. And this has some fun facts about our firm.
Perfect. Thanks, Leah. I was just going to say it is 7:11 right now, so we'll try and start this up at 7:15 or so. Just a reminder, if anyone happened to join, mid presentation there, we do have a chat box at the bottom, so feel free to ask any questions or any comments down there, and we're going to try and answer all of those at the end of the presentation. So we will pick this up in a couple minutes. All right, well, it looks like it's 7:15, so Leah and Tyson, whenever you're ready, let's get back into the presentation here. I can't hear Tyson. Is that just my computer?
No, I can't hear Tyson either.
Okay, I just wanted to double check that it's not just me. No.
Can you hear me now?
No. Oh, there we go. Yeah, that's
Oh, is
better.
that better? Okay, I don't know
Yeah.
what happened there. My headset turned off or something. Sorry, everybody.
No worries. Yeah, take it away.
Yeah, it may be that listening to the prior part of our presentation about all the things that go into a will, maybe that you felt a bit overwhelmed and thought, well, why don't I just not have one of these things? Sounds like a lot of work. Well, here's why that's problematic. Not having a will, there's essentially a one-size-fits-all sort of regime that happens to your estate, and there's a whole bunch of things that it doesn't provide for. Obviously, there's no, I'll get into exactly what the regime is, but there's no provision for stepchildren who may be very important to you, siblings, nieces, nephews, charities, friends that you might want to provide for. So there's no way for you to customize what's going to happen to your estate. If there's minor children who stand to benefit if you die without a will, their share goes by default to the public guardian trustee to be managed until they're 19, and then they get it all, which, as Leah mentioned, is problematic because maybe they're not financially mature yet. And there's no executor because you don't have a will. So that means that one of your next of kin has to step up and apply for what's called administration, which is a similar process to applying for executor, except that there can be a big fight about who should do it. And there can be situations where no one wants to do it, and then there's situations where everyone wants to do it, and it can cause a big hassle. There's no guardian appointed for your minor children, and as I said, no executor. So lots of problems that arise from that. Oh, there we go. And now I went too far. So if you die without a will, here's what the regime is. It depends on whether you have a surviving spouse, and it depends whether that spouse is a parent of your children, if you have any children. So if the children are common to you and the spouse, then their share is $300,000, their preferential share, and then half of what's everything else, the other half going to the children. If it's a blended family situation and your spouse is not the a parent of your children, then their shares is at $150,000. So that's how the legislation sort of sets out what's going to happen to your estate if you die without a will. What can go wrong? We've had lots of examples of that in Leah and my practice over the last number of years. There's the first example there, and often these are from blended family situations. If the wealthy husband, all the assets were in his name, he died without a will, and he had, lo and behold, two estranged children who he hadn't seen in 30 or 40 years. And now all of a sudden they stand to inherit almost half of a substantial estate. And obviously he could have, affected that if he had had a will. A single parent with one young child passed away without a will. And in this case, we acted for the grandmother who stepped in. The father wasn't in the picture. The grandmother first had to apply for guardianship of the child because there was no guardianship provision in the will. Then she had to apply to be to administer the child's money that he was going to receive from the estate. He was only 9 or 10 years old, and it otherwise would have gone to the public guardian and trustee by default. And the third one there, if a husband passes away without a will, the property's in his name, the bank account's in his name, and the wife can't access the money in the bank account to pay the mortgage. And the house ended up going into foreclosure before she could get that grant of administration. So those are just some examples of what can go wrong if you don't have a will. Another topic that comes up a lot in my practice dealing with disputes is joint assets. And Leah mentioned this a couple times at the start. This is one of the tools of estate planning is joint assets. And there's a lot of pros there, as we've listed, and that attract people to this. And the biggest one is if you have a joint owner to something, then you don't have to pay probate fees on it, or don't necessarily have to pay probate fees on it. Those assets can be dealt with more quickly because probate's not required. You can also use this as a means to gift something even before your death, if you want to do that. And some people are concerned that the probate process could result in some, their financial information being publicly available, and so this allows more privacy and confidentiality. But there are a lot of cons, and there are particularly a lot of cons for people who try and do this sort of on the quick without thinking about it or getting it done correctly. Joint ownership exposes your assets to creditors of the other owner. So I had a situation a few years ago where an older fellow came into the office and said, I put my daughters on title to my property years ago, and now one of them's, her business is failing. I'm worried that the creditors are going to come after it. And so we had to sort of slap together a solution for him to try and do the best we could with the bad situation. But that solution might not have held up, and the creditors could have come after him. You lose obviously the control and autonomy over your asset because you can't undo joint ownership without the consent of the other owner. And this is a couple of the saddest cases I've ever dealt with involve this very principle or idea where everyone's getting along, and mom adds 3 kids to title to her property as joint tenants, and then she has a falling out with one of them. And years later, she wants to sell to downsize, to move into a condo, and the child she had a falling out with says, sure, pay me my share and I'll let you go. And because now he's got control of that asset because he's got to sign off before she can sell it. So that's a real consideration, and one that people don't, I think they expect that their kid's going to do the right thing, but if you have an estrangement situation, a big argument and a fight, you don't know that that's going to happen. And the biggest thing that crosses my desk is confusion about what the person really intended. So you've got 3 kids, you name one of them as your executor, and you add that same child, the executor, on title to your house. Now, when you die, did you want the executor to get that house in her own right, or did you want her to have to share it with her siblings? If you don't make that clear, then there can be a fight after your death about what you intended. So it's really important to make sure this is done right if you do this sort of estate planning. And it can also trigger tax consequences. So that's another thing to sort of be on the lookout for with these joint assets. And now back over to Leah to talk about multiple wills.
Great. Yeah, so the notion of joint tenancy planning is something that we talk about with our clients all the time, and people will often come in the door with the idea that this might be something that they want to do, and it's often to save probate fees. And again, I would remind them that the probate fees here are minimal 1.4%. That's far, far less than what you're going to be paying in capital gains tax. So often the mischief that can result from this type of approach far outweighs, creates far more problems than what you're solving. So I would highly caution you to use that with a lot of caution and only with professional advice of a lawyer. So then when moving on, we're talking about the other tools available to us when we're planning estates. And these next 2 topics are really important or really relevant to folks who are wealthy. And this one example of multiple wills, this means having, if I'm the client, so I'm a client and I may have 2 wills. And it would be useful for me if I held shares in my own small business. So if I was a business owner and I had amassed a lot of wealth through my corporation, and I held the shares of that corporation, and if I only had 1 will and it had to go to probate, then the entire value of my corporation would also be disclosed to the court, and probate fees would be calculated on the value of my corporation and paid. So if I had a $2 million company with $2 million of investment assets in it, the probate fees on the company value would be almost $30,000. So what can be done? Well, I can actually make 2 wills. I can make 1 will dealing with just my company shares, and I can choose an executor to handle that. So that executor's job would then be to transfer my shares to the executor themselves, and then from there to the beneficiary I've named in the will. And that can all be done through internal company arrangements. So the directors of the company who substitute in after I die, and often that's the executor takes over control of the company as a new director and signs the paperwork to have the shares transferred to the executor and then the beneficiary. So that doesn't involve a third-party institution like a bank or a land title office. There's no third party here that wants to be assured that the will is valid and the executor is the right person. So that can be done with internal company procedures. So that would be one will handled by one executor. Then I would have another will, which would be covering all of my other assets like my land and my bank accounts and my investments that I hold personally and my vehicles and my personal effects. And I would assign a different executor to deal with that will. And we know, because of the complexity of the estate, we know that what it's made up of, the complexion, the type of assets. We know it's going to go to probate because I own land and I own investments. So I know it'll be probated, but that executor only has to declare and pay probate fees on the assets they're in charge of. And they're not in charge of the company shares. That's dealt with under a separate will by a different executor. So these two executors have operating under different wills, managing different pots of assets, working simultaneously, and they each carry out the terms of their own particular will. And in that way, I've sheltered my corporate interests, my corporate shares from probate fees, and we've saved probate fees. So it sounds a bit complicated, but when done nicely, it can be a really nice, slick tool. And the other tool in our toolbox here for wealthy clients is something known as an alter ego trust or a joint partner trust. And the idea here is, if I was the wealthy client, I could set up a trust while I'm alive. I'd create a trust now, and I would control that trust myself as trustee, and I would contribute to it my valuable assets. So maybe my investment accounts and my house and my corporation shares of my small business. And I would remove those assets from my estate and I would put them in my trust. And it's called alter ego because it's kind of like another version of me. So I'm in charge of it until I die. And then when I die, that trust document itself actually sets out who the beneficiaries are. So it kind of works like a will. It describes where those assets are going to go. And then majority of my wealth is tucked away in this trust. And I may have an estate, but it's probably a very small one. Maybe it only has 1 or 2 vehicles and a couple small bank accounts that I didn't bother to put into the trust. So my estate would be governed by my will, and I would have an executor. And those two, so the executor and then the trustee of my trust, will kind of work in tandem to manage what happens after I die. But the beauty here is that the estate is minimal. So there are minimal probate fees because I've put all the expensive assets into the trust, and there's no probate fees when you're administering a trust. All my assets are held and managed by one trustee already, so that trustee is already in control of them. So it's a fairly streamlined process when I pass away. They already have control. Tyson mentioned privacy. That's a concern. So that list of assets that has to be filed when an estate is probated, well, that list can be very small if there's not much in the estate because everything is in the trust. And then wills variation, and this is quite honestly one of the main reasons we use these planning tools and these trusts, is because what's left in the estate is minimal. And so we've really just contracted and shrunk what's available and what's at risk for a claim by an unhappy spouse or child. So we've prevented a claim by isolating and protecting those assets into this trust.
Briefly, I can see it. We're at 7:30, so I'll be very quick. If there's a blended family situation, like I said, that's what gives rise to a lot of disputes. There's lots of different options that that an estate planning lawyer can use to try and reduce the risk of a dispute in a blended family situation. So some of them are sort of generally outlined there. But the big concern is that the surviving spouse is free to change his or her will, so you can't necessarily rely on them benefiting your children if you happen to be the first one to die. So that's the big concern in blended family situation.
Okay, thanks, Tyson. And so I'm just going to wrap up here with just a quick discussion on incapacity planning. So we plan for wills, but we also plan for what happens if you're living through a prolonged period of your life where you don't have capacity. You do need to set up a power of attorney ahead of time to appoint somebody who has the ability to manage your affairs for you. So we're talking about financial and legal matters here, paying bills, handling investments, selling assets, figuring out insurance, selling a house, et cetera, et cetera. It's a common misperception. People think, well, because we're spouses and we have joint accounts, my spouse will be able to just handle everything for me. That's not truly the case. They may need to sell the house, and they can't do that. They can't sign your signature unless they have a power of attorney. So that's often overlooked. And if you're talking to your parents who insist that they already have a will and they don't need to update it, ask them if they have a power of attorney, because wills done 20 or 30 years ago may still be valid and good enough, but I pretty well guarantee you they never made a power of attorney back 20 years ago. So that really does need to be done. And yeah, this is just the rest of that slide. And the last point here is what happens if you don't have a power of attorney? And this will happen more often than you think. Somebody loses capacity in their 80s or 90s. There's no power of attorney ever done. And the children, usually in this case, need to start dealing with mom or dad's assets and managing things for them while they're outliving or living out their life. The only option available here where there's no power of attorney is something called a committeeship. And this is, very simply put, it's a court order from the BC Supreme Court that declares the parent incompetent, unable to manage their affairs, and appointing the kids as the guardian for the parent. So that would allow the kids then to start managing affairs. There's living wills. Those are different components as well. So this is basically a do not resuscitate type direction. And it's talking about healthcare. So end of life care planning. And you may want to do a living will, which states that you don't want your life preserved if death is imminent. And of course, this is not a substitute for medical assistance in dying. That's something entirely different. And the last point here is the medical representation agreement. So this you can think of as being like a medical power of attorney. So again, you're choosing a decision maker. You're appointing them and authorizing them to make medical and personal care decisions for you. And their authority is broad in scope. So it's talking about very, very mundane things like taking you to the dentist or getting you a haircut, to what type of diet you have in your care home, who you associate with, and all the way through to what type of medications you have, treatments you're given, and then what kind of end of life decisions are made. Very broad scope. There's a pecking order that sort of applies to a very limited scope. If you don't have a representation agreement, typically starts with a spouse, and your spouse may have some limited ability to make medical decisions for you, but it's not nearly quite as broad. So we wrapped up that last component quite quickly on purpose because we wanted to leave ample time for questions. So I will now just turn it over to Brendon to lead us through the question component.
Perfect. Yeah, thanks, Leah and Tyson. That was great. Lots of good information in there. I know that not everyone can necessarily stick around right until the end, so we're not quite done. We're going to get into the questions, but for the sake of time, for anyone that does have to leave, I want to encourage everyone to attend some more of our Embrace Aging Month events. So I would encourage everyone to check out our website, OkanaganEmbraceAging.com. That's all one word. OkanaganEmbraceAging.com. That will take you to a list of our other events where you can register. We are looking to grow and expand these events, so if you're interested in participating, please reach out to us. The contact information is all on the website. And for anyone else that has to leave, you will get an email after this with a survey, so please give us some feedback. And if you have any other questions or comments, you can definitely take advantage of that there. So let's take a look here. So some of these questions, Leah and Tyson, I know that you've probably answered some of these, so I'm going to try and get you the best ones here, but let's start with this. How effective or legal is a codicil? And please explain what it is and when it should or could be used.
Okay, sure. A codicil is, simply put, it's an amendment to a will. So it can be done to make a simple change to an existing will. And it has to be, the same formalities apply. So it has to be signed by the will maker or the codicil maker in the presence of two witnesses. Those witnesses can't be named in the documents or spouses of beneficiaries. And they all have to be in the same room at the same time. So it's an amendment, an addendum, and it's just as valid as a will. So you have to be very careful when you're making a codicil. You may end up undoing a whole bunch of really good planning that your lawyer has done. Codicils should be made with lawyers, not self-help options.
Perfect. Okay, let's see here. This one, I don't know if we touched on this. What are the implications of a US-Canadian dual citizen living in BC, having a dual citizen executor beneficiaries who both live in the US?
Sure, okay, I can take this one. So a person who lives in BC is also a citizen of the USA, and the next of kin beneficiaries are USA residents and or dual citizens. So that is there's a lot of implications that can flow from this, and it's too broad of a question to dive into with any amount of detail, but I will just let you know, you do need to talk to an estate planning lawyer and probably a tax accountant specialist with specialties in cross-border taxation, because as you will already know, you'll have annual filing obligations in the USA, and you potentially may have FBAR or financial bank account reporting obligations in the USA. That will continue for your estate. And distributions to your beneficiaries who are foreigners and live out of the country, those have to be paid special attention to for tax reasons when your estate's distributing. There may have to be holdbacks from what they get, holdbacks until Canada Revenue Agency signs off on the distribution. So there is a lot of layers to that little onion, yeah.
Yeah, and just for everyone on the webinar, we do have to be mindful that we are not tax professionals. So like Leah said, sometimes an accountant would be the best person to talk to. But speaking of taxes, we have a question here. If a senior puts their adult child on joint tenancy with right of survivorship and that child resides with them as their caretaker and is also basically the child's primary residence, are there tax implications, capital gains, etc., when the parent dies?
Do you want me to take that one, Tyson, or?
Yeah, sure. Go ahead, Leah.
Sure. So I think the optimal way to set that up would be parent adds child to title, and it's done with some legal documentation that a lawyer would draw up that would confirm that even though the child is actually being added to the title, they're only there as a bare trustee. They don't take a beneficial interest in that property until their parent dies. And then as of the day their parent dies, then they would become the owner of that property beneficially. And so that then would preserve the whole principal residence exemption for the parent. So when the parent dies, the principal residence exemption shall usually be able to shelter the whole disposition that's triggered by the parent dying, and then no capital gains tax would be paid on the parent's death. Going forward, the child would be responsible for tax on any gain in value.
Okay, perfect. And I actually have another one here that I think we can kind of piggyback off that last question. So this question is, how is a house dealt with after the owner passes away? If the house is willed to the children, would it then get transferred to them after probate, or would it be sold from the estate of, and then the proceeds going to the children?
I can answer that one, Leah.
Sure.
Generally speaking, it depends what the will says. If the will says, give my house to my children, then the executor is supposed to transfer title to the children. But most wills say, take my estate, collect all the money, and divide it up amongst my beneficiaries. And in that case, the executor's job would be to sell the house and divide it amongst the children. Of course, sometimes the children might say, well, wait a second, executor, we want to keep the house. So don't sell it. We'll take it, or one of the children steps forward and wants part of the house as part of their share of the estate, and can get quite complicated. But basically, it gets sold in the normal course. It would get sold by the estate, and the proceeds given to the children.
Perfect. Thanks, Tyson. Leah, you might have briefly touched on this, but this is a pretty quick question. How often would you recommend updating a will?
Rule of thumb is every 5 years, but I like to think of it as think about who your people are, who your key people are in your plan. And if something happens in their lives that might affect their ability to be part of your plan, then you need to pull out your will and see what contingencies you've built in there, what your alternate executor is, and does that still apply? So 5 years at most, but then life events, your marriage, your child's divorce, a death in the family, all those things should be triggering a review of your will.
Perfect, thank you. We have kind of a longer question here, so there might be a little bit to unpack. So I'm going to read this one out nice and slow. So it says, my husband recently passed away with a will and with myself named as the executor. Everything with the exception of 2 BC registered trailers, which they were under $8,000 combined, and they were named in the will. So basically everything else was held jointly with rights of survivor, or she is the designated beneficiary. He had no individual debt, and the line of credit secured by our home easily covered the home value. That's also in both names. The last time that they updated their estate, I'm assuming that means will, was back in 2012. The paperwork looks completely different now. I'm unable to find a clear determination on whether, due to the small value of my husband's estate, if I even need to do the grant of probate. If not, what will Revenue Canada want when it comes time for the clearance certificate? So yeah, basically it looks like there's not a whole lot of assets. So what are the rules around, I guess, the size of an estate that has to be probated?
Great question. So there really is no threshold about how big of an estate is going to require probate. Again, it just depends on the type of assets that are in the estate. In this case, we know that the assets are 2 trailers, and their trailer registration is managed through Manufactured Home Registry in Victoria, an arm of the provincial government. So in order to sell the trailers, they have to know who the rightful person is to manage that estate. So thankfully, there is an exemption. Under that legislation, there's an exemption for assets or estates under $25,000. So you just need to go and talk to the Manufactured Home Registry, and they will give you the affidavits and the forms you have to fill out, and you will swear to the fact that the estate is under $25,000 and that you're not probating it for any other reason. And then they will let you transfer the trailer to yourself as executor of the will, and then there you can sell the trailer or do whatever you want to do with it, whatever the will tells you to do. And then the second part of that question was, what will Revenue Canada need if I'm not getting a grant of probate? What do they need in order to deal with me and give me my clearance certificate? That's another great question. Thankfully, in this case, there is a will. That's all they need. So the will speaks from death. It's operational as of the day the will maker dies, and the executor has powers and authorities granted under that will. So Revenue Canada will recognize the will and the executor named there, and when they have the death certificate, they'll be able to deal directly with the executor, even though there's been no grant of probate issued.
Perfect, thank you. Okay, this one, I don't think we touched on this yet. So the question is, we relocated from Alberta 3 years ago. We have a current will and power of attorney. Are they valid in BC?
It's a great question. So wills throughout Canada, generally speaking, except for Quebec, are most of the time universal. So a will made in Saskatchewan has the same technicalities and validity requirements as our BC wills do. it doesn't have the same underlying laws, like it doesn't have wills variation laws or probate fees to speak of, but the will itself, the document will probably be valid, but you should have it looked at by a lawyer. The key thing here is though that power of attorney. So if you have assets now in BC and you become incapacitated and your spouse needs to deal with them and all they have is an Alberta power of attorney, British Columbia institutions, land title offices, banks, they're not going to recognize that Alberta power of attorney because it's not made under BC legislation. So they would have to send that, the person appointed in the power of attorney would have to go back to the Alberta law firm, get a certificate saying it was, and basically have it re-recognized in British Columbia. So that can be done as a last case resort, but not recommended. It's far better off, in my opinion, to just do a British Columbia power of attorney to deal with your BC assets. If that person has lost capacity though, and it's too late, then there's still that recognition process available as a last case resort.
Okay, perfect. I've noticed a few questions that are kind of, in the same topic of contesting wills. So let's maybe tackle a few of these kind of at the same time. So there's one here. So what should you do if your child has said they want nothing to do with you and therefore you've decided to leave them very little? Would it help to attach an email, from the child to the will to sort of, justify why you're not leaving them very much?
Yeah, I can feel this one. I haven't seen that done before, attaching an email from the child. That would be a unique way to do it. Quite often what the will maker would do with their disinheriting a child or not leaving them very much, they often leave a note or a memorandum along with the will or even inside the body of the will saying why it is that they've chosen to leave that child less of a gift. And so you might include, write that memorandum and include with that the copy of the email from your child. The issue with doing that sometimes is that if you don't, if you say a whole bunch of things in this memorandum or this statement that some of them aren't true, then it's possible that if that child does challenge your will and they go to court and say, look, court, my dad said X, Y, Z and X and Y aren't true at all, then the court might say, well, I'm not sure that this disinheritance is really fair. So that's the only downside of making a statement, is you want to make sure that it's founded, well grounded in fact, and that I think some people tend to exaggerate a bit to try and emphasize these, how terrible the child's treated them, and they end up it being counterproductive because then they undercut their own reason for doing it by saying things that aren't true.
Yeah, well, that's some good points there. So there's another one here. Can the spouse of an adult child contest a will if the adult child has died and the will says that the child's portion of the estate goes to the other children?
No, and if we're talking about contesting a will on the basis of what we talked about, wills variation, there is another type of contest that where the person who's contesting it says the will's not valid for some reason. That's sort of a different kettle of fish, and it's conceivable that a spouse might be able to make that kind of claim if they were provided for in a previous will. But no, in terms of wills variation, the spouse of a child would not have a claim.
Okay. And there's one more here. Do you have to list your adult children in your will, even though you do not plan to leave them anything? This person has no assets except for furniture and plans to leave it to charity.
No, you don't have to make a list of those people, particularly if there aren't enough assets for them to want to challenge in your estate anyway. No, there's no requirement that a will has to list children or any particular family members.
Okay. Let's move on to some other questions here. So this is a pretty short question. I don't know if this is a legal term or not. It just says, could you please explain faith and trust? Does that mean anything to you guys?
No, I think we'd need more context.
I suspect that might be a typo or something like that.
Yeah.
If you're still in the webinar, whoever sent that question, maybe expand on that if you can in the chat, and we'll try and circle back to that if we still have time. Okay, this one is more about businesses. It says, if you have a company that holds property, can you give it to a child in the will and they would then operate it or close it as they wish?
Yeah, absolutely. So that's just like giving the vehicle to a child or giving the house to the child. Instead, you give the shares of the company to the child, then they become the shareholder and the owner of the company. And at that point, if they're the only shareholder, they can make themselves a director, and that director's job is to run the company. So they can run the company for as long as they want to, or they can sell the assets within it and wind up the company. So that's definitely an option, yeah.
Perfect. Okay, this one is interesting one about the Wills Variation Act. So it says, should a deceased parent having resided in Alberta with some children beneficiaries living in BC, are they still able to contest the will via the Wills Variation?
Oh boy, this is one of the nerdiest legal areas you can possibly get into, conflict of laws. Generally speaking, though, the place where they resided at the time of their death, that's the laws of those places will apply to their estate. There is an exception if that person owned property in British Columbia, then there could be an exception to that. But generally, the rule is where they were ordinarily resident.
Okay, perfect. Well, here's one specifically for you, Tyson. The question reads, Tyson, you spoke about a person transferring title to a child who's also the executor. If you meant to leave it to this child, the executor, how would you approach this in the right way to ensure that it's not contested after the fact?
Well, there's a number of things you can do, and they all stem from what I suggested were the cons of transferring properties into joint tenancy. The biggest thing you want to do is to document what your intention is. And I could go on at length about why that's required, but essentially when you transfer an asset into joint tenancy for free, so gratuitously, your child isn't paying you anything for it, the law presumes that you actually intend that child to hold it in trust for your estate and to distribute it according to your will. So that means that that if you want to make sure that child gets it, you definitely want to document your intention. And the best time to do that is the time you transfer it to them. And as lawyers, what we do when we're drafting these things, we do what's called a deed of gift. It doesn't really matter what the document's called, it matters what the contents are. And the contents basically say, I'm transferring such and such property into joint names with my daughter, Jane. I intend to be the sole beneficial owner during my life, but when I die, I want Jane to be the beneficial owner, and I don't want this property to go through my estate or be subject to my will. So that's basically the kind of language you would want in there. Obviously, the best thing to do is to have that done up by a good estate planning lawyer. Doing it yourself has got a lot of pitfalls, but that's the kind of documentation you'd want on there.
Okay, perfect. Just for a quick time check, we have about 5 minutes until we need to wrap this up. So let's try and get maybe a couple more questions in here. Do you guys have any opinions on whether it's a good planning tool to pre-plan your funeral arrangements?
I always tell my clients, yeah, absolutely. If it's something you're interested in looking at, you can go speak with a funeral home or some like pre-planning arrangements, like when the BC Memorial Society, pardon me, is a good resource, and you can find them online. So the idea with the pre-planning is basically that you're choosing the package that you would like for your funeral and your service, and you're prepaying, or essentially you're actually buying a contract where they agree to provide you with these services for this price. And then your estate gets the benefit of that locked-in price, even if prices have gone up in the industry, funeral costs have gone up in the intervening 15 or 20 years before you passed away, you've locked your price in back in the day. But there's more to it than that, because the funeral directors will go through really, really carefully with you, and they will create a file for you, a file on you, for information that your executor may need. Not your executor necessarily, but those who are planning your funeral. So they will ask you things like, where were you born, and what were your parents' names? All those things that have to be in the obituary and nobody thinks to ask, they have created this file on you.
Perfect. And well, there was another question about the Memorial Society, so I think you've answered that one, so that's perfect.
Okay.
Okay, what else do we have coming in here kind of at the end? I don't think we touched on this one too much. If a person dies with debt and there's no assets left, is the executor responsible for the debt?
Oh, that's a really good question. So this should not be taken as legal advice because every situation is factually different, but generally speaking, no. If the executor looks at this estate and says there's nothing in this estate, there are no assets to pay the debts, and the executor has not guaranteed the debts or taken on the responsibility for paying back the debts, then they are not responsible for it. But they have to be very careful that they don't deal with what assets are there in the wrong priority. They have to pay, if an executor is assuming the role as an executor and agreeing to be the executor, they have to do it properly, and they have to pay back the creditors in a certain order of priority, and they have to make sure that priority is followed. If they skip somebody, then that executor may be personally responsible for the shortfall. So if it's an insolvency situation, that executor really needs some legal advice right at the get-go before they even decide if they want to tackle this and take it on. They may not want to, they may just want to resign and step away.
Okay, that's great. I think we're going to do one more question here before we wrap this up. So let's see here. We don't have that many left. I don't know if you touched on this specifically, but how is an estate distributed if there's no will, but there's also no spouse, children, or parents to handle it?
Siblings. Siblings are the
Okay.
next of kin. And then one of the siblings would have to apply to the court to become an administrator and give them the power to manage the estate.
Perfect. Well, thanks, Leah and Tyson, for answering all those questions, and thanks for submitting that, everyone. We had some really good questions come in. So on behalf of Embrace Aging and Interior Savings, I want to thank everyone for joining and participating, and thanks again to Leah and Tyson for all the valuable information. I did notice in the chat panel there are some links to the Memorial Society that people can access, and we also have a link there to our OkanaganEmbraceAging.com. So once again, I encourage everyone to check out that website. It has our contact information, and it also has links to register to some of our other events. Other than that, you will definitely get some emails, so please give us some feedback, anything that we can do to improve, and if we missed any questions, let us know there, and we will definitely try and get back to everyone after the fact. So yeah, it's pretty much 8 o'clock any second now, so I think we will shut this down. So I hope everyone has a great evening, and thanks again for attending.
Thank you.
Thank you, Brendon.